In this video, we're going to be looking at two key cases, Oughtred and IRC and Gray and IRC. And this really follows on from our previous videos where we were discussing the formalities for a trust, and we talked about specifically the Law of Property Act, section 53, which provides that transactions for the creation or disposition of an interest, either beneficial or legal interest, in land must be in writing and signed. And then we also looked at that the trust of land must be evidenced in writing and signed, and that any disposition of an existing or subsisting equitable interest must be in writing and signed. And if you don't understand what I just said there, go check out the previous video where I do explain what I just said in a lot more depth. But specifically in this video, we're going to be looking at the Law of Property Act 1925, section 53, subsection 1c, and these two cases. So section 53 1c, a disposition of an equitable interest must be in signed writing. A disposition of an equitable interest or trust subsisting at the time of the disposition must be in writing, signed by the person disposing of the same or by his agent thereunto, lawfully authorised in writing or by will. So a disposition of an equitable interest is required to be signed writing and not just merely evidenced in writing. Otherwise, the disposition is void. And our disposition includes a range of methods for transferring an equitable interest, so that could be a gift or like a sale. And notably, a declaration of trust does not constitute a disposition of an equitable interest, because a declaration of trust affects the creation of an equitable interest rather than a disposition of a pre-existing equitable interest. Therefore, section 53 subsection 1c does not apply to declarations of trusts. Okay, the purposes of this section is twofold. First, to prevent hidden oral transactions in equitable interests, defrauding those entitled to property, and secondly, to enable trustees to know where the equitable interests are at any one time. Perhaps surprisingly, given the context of the statute, it comes immediately after the provision that the creation of a trust of land must be in writing. The provision applies to all property, real and personal. So this is surprising because every single section is about land, so why would you have a provision that applies to something which isn't land? On a literal interpretation, it doesn't actually say land, but must be construed in context, so you would presume it only applies to land. But it is arguable it could apply to any and all types of property and not just land. And in the Act itself, it says that equitable interests means of land. So who knows why the courts have interpreted it in the context of personal property too, to be honest. Section 53 1c applies when a beneficiary under an existing trust transfers the beneficial interest in the property to another person. So as said before, it is not about the declaration of trust, as this is not a disposition. A disposition is required. The requirement that the disposition must actually be in writing, if not complied with at the time, clearly cannot be rectified subsequently unless there is a fresh independent disposition in writing, and accordingly it always seems to have been assumed that the absence of writing makes the purported disposition void. And this view seems to be implicit in these two important decisions of Oughtred and Gray. So let's look at Oughtred and the Inland Revenue Commission. So Mrs. Oughtred had a beneficial life interest in shares in a private company held under a trust, with her son owning the reversion. In other words, when she died, the shares would be held on trust for her son. So 200,000 shares in a company were held on trust for Mrs. Oughtred. Then when she died, the shares would be held on trust for her son. Absolutely, they would be held on trust for her son alone. And Mrs. Oughtred was also the absolute legal and beneficial owner of other shares in the company. So although there were 200,000 shares held on trust for her, she also owned 72,700 shares outright. Mrs. Oughtred orally agreed with her son to swap his reversionary interest in the shares for some of the shares she owned absolutely, so that both would own a parcel of the shares absolutely. By combining the life interest with the reversion, Mrs. Oughtred was able, under Saunders and Vautier principle, to direct the trustees to transfer legal title to herself. In other words, to reduce the estate duty, that is the tax paid on the property left by a dead person, which would be payable on Mrs. Oughtred's death, an oral agreement was made under which the son would surrender his reversionary interest in the settled shares, that is the 200,000 shares, in consideration for the transfer to him of his mother's 72,700 shares. So this meant that they could both own a parcel of shares absolutely. The son has the 72,000 shares that Mrs. Oughtred used to have absolutely, and the 200,000 shares that were currently held on trust could be claimed. In other words, she could claim absolute ownership of the shares by Mrs. Oughtred using the principles under Saunders and Vautier. In other words, where the beneficiaries are sui juris, that is over 18 and sound mind, they can require the trustees to vest their legal title of the property in them. So the fact that she had the life interest and the reversionary interest meant she could claim the absolute title in the shares from the trustees under this principle. Now, 3 written instruments were prepared. One transferred Mrs. Oughtred's shares, previously held absolutely by Mrs. Oughtred, into the name of her son. The second indemnified the trustees against liability and recorded that they had acknowledged that they now held the shares absolutely for Mrs. Oughtred. The third was the transfer of the legal title to the shares from the trustees to Mrs. Oughtred. So just to clarify, the second document was a deed of release given to the trustees in respect of anything done by the trustees in the execution of the trust of the settlement. That is, a deed of release is where beneficiary releases the trustees from the obligations. And the IRC assessed whether ad valorem stamp duty was payable on the transfer of the shares from the trustee to Mrs. Oughtred. That is on the third document, the disputed transfer. So in these days, what was taxable was the document itself. So any piece of paper that transferred value was taxable as a document. So checks were subject to stamp duty, for example. What stamp duty did is very important to work out whether a document transferred value, because if it did, it was ad valorem, meaning the higher the value of the transfer, the more tax that was payable. The IRC argued that the oral contractual referral of the son's reversionary interest to Mrs. Oughtred could not be considered a disposition of shares, because under section 53(1)(c), this needed to be done in writing. So the mother and son agreed to exchange their interest, which the IRC claimed was ineffective due to section 53(1)(c), and the IRC claimed stamp duty on the actual written transfer of the shares, which happened later. The contrary argument was that the effect of the oral contract was to make her son a constructive trustee of the reversionary interest in favour of Mrs. Oughtred, so that the entire beneficial interest had already passed to her before the disputed transfer was executed, and, as we have seen, a constructive trust is exempted from the requirements of writing by section 53 subsection 2. If this had been the case, it would have been the oral contract and not the document that had transferred the value, and therefore no stamp duty would have been payable. It has, and in the judgment, Lord Jenkins said, "It is said and said truly that stamp duty is imposed on instruments, that is documents, not transactions, and that a transaction of sale carried out without bringing into existence an instrument which had the effect of transferring to or vesting in the purchase of the property sold attracts no duty. So Lord Jenkins is saying here that stamp duty is payable on documents only and not transactions. And also just note that today it is the transactions that are taxable and not the documents, which is far more sensible. It would have been sensible to argue that, as this case is about personal property, the Law of Property Act does not apply. And they applied section 53 1c literally, in that it can apply to all interests here. As section 53 1c has not been complied with, i.e. the disposition had not been made by writing, when the son told the trustees to transfer his reversionary interest to his mother, it had no effect, and this meant that the value was transferred in the documents and not the oral contract, and therefore was taxable under stamp duty. The House of Lords held that the oral agreement between Oughtred and her son created a constructive trust, but that did not prevent the third document from being liable for stamp duty. Take the simple case of a contract for the sale of land. In such a case, a constructive trust in favour of the purchaser arises on the conclusion of the contract for sale. But, so far as I know, it has never been held on this account that a conveyance subsequently executed in performance of the contract is not stampable ad valorem as a transfer on sale. So the basis of this decision, adopted by the majority, was that even if the oral agreement was effective to pass the equitable interest in the settled shares to the mother, the transfer, as the instrument by which the transaction was completed, was nonetheless a conveyance within section 54 of the Stamp Act 1891, but different views were expressed as to whether section 53 subsection 2 applied. Okay, so that was the case of Oughtred and IRC, and we've also got the case of Gray and IRC, and that's what we're going to be looking at now. So Hunter, this guy called Hunter, created 6 trusts in nominal amounts for the benefit of family members. He then transferred shares in a company to 2 trustees to be held on trust for himself. So this man, Hunter, was attempting to transfer title in 18,000 valuable shares to his grandchildren. He had created 6 settlements, that is 6 trusts, of nominal sums, so of very small amounts of money, 1 for each of his grandchildren, and sought a means of passing 3,000 shares into each settlement without liability to stamp duty. Therefore, he created a trust over the 18,000 shares and declared himself to be the sole beneficiary. As the beneficial interest in the property, that is the shares, was not transferred, i.e. the legal interest was transferred but he retained the beneficial interest, there was no tax payable on this transaction. He later directed the trustees orally to hold the shares on the terms of the 6 trusts previously created. He hoped thereby to avoid paying ad valorem stamp duty, which was payable on written instruments, not on transactions. Later, the trustees executed 6 documents confirming that they held the shares on trust for the family members. So he then directed his trustees orally to transfer his equitable interest in those shares under the new trust to the trust held for his grandchildren, before subsequently writing these instruments down with the trustees. So in other words, he first transferred the shares to the trustees for his benefit, but later orally instructed the trustees to hold the shares for the benefit of his grandchildren. Then at a later date, written declaration of the trust was made confirming the oral instructions. The House of Lords held that the transfer of the equitable interest in the shares was not affected by the oral declaration, but by the deeds executed by the trustees. Accordingly, stamp duty was payable. So his intention was to pass title by means of the oral instructions and not by means of the writing. However, Lord Simmons in the House of Lords held that title did not pass until the instructions to make the disposition were put in writing, and therefore that it was the writing that transferred the equitable interest, and in consequence the stamp duty was payable. So the court found in favour of the IRC. And just to put this another way, Hunter's attempt to dispose of his equitable interest in the shares by the oral declaration had been ineffective because it had not been made in writing as required by Section 53, subsection 1c of the Law of Property Act 1925. So it was the later declaration made in writing that was the effective disposition of Hunter's equitable interest in the shares, and because those shares constituted instruments for the purposes of the Stamp Duty Act of 1891, they had been rightly been assessed to be subject to ad valorem stamp duty. So, what is the distinction between these two cases? In both, it was held that the oral direction to the trustees to hold the shares on trust for another beneficiary was ineffective. However, in Oughtred, it was held that the trustees held the beneficial interest on a constructive trust for Oughtred. In other words, the transaction was effective under a constructive trust. In Gray, it was held that the oral declaration had no effect and the trustees held the shares on trust, i.e. for the benefit of the original owner. Okay, and so Mrs. Oughtred had consideration, hence the difference between the cases, whereas in Gray there was no consideration. It was a gift, so there was no constructive trust. The difference between the cases is that Oughtred was providing value by transferring her other shares into her son's name, and Hunter was making a voluntary transfer. So, and it soon became apparent in many tax contexts to demonstrate that equitable property could pass without the need for a document. The collective mind of the tax lawyer was therefore focused on a means of transferring rights in property without the need for signed writing under Section 53, 1c. And the litigation which probed the perimeters of the rule in Section 53, 1c was that revolving around the estate of Mr. Vandervell, and we're going to look at that case, the Vandervell case, in the next video, because that requires a video of its own because there's quite a lot to say about it. But that really wraps up Gray and Oughtred, and I understand again this can be quite difficult to understand and comprehend, especially at the early days of your trust course. So if you want to ask any questions, please leave a comment below. You will, I think, understand this a lot better as you move throughout the course, and once you've finished your sort of the module itself, it'd be quite a good idea to review, Gray and Oughtred with your sort of complete knowledge of trust and equity. But I'm happy to help anyone who needs it, and if you have any questions, please just leave a comment below. Make sure you subscribe to my channel, and I shall see you next time. Thank you very much for watching.